I left off in reading BARBRI, Commercial Outline, Criminal Law, on page 14, in section 2, and I'm talking about mental state. Section 2 is about essential elements of a crime, which is why, of course, we're in the mental state section. I believe we were in the analysis of statutes using fault standards. One, state of mind applies to all material elements of offense. Often, a statute will establish a culpable state of mind without indicating whether it is required for all the material elements of the offense. In that case, the specified state of mind applies to all material elements of the offense unless a contrary purpose appears in the statute. Here's an example. Under a statute imposing criminal liability on anyone who knowingly makes a sale of intoxicating beverage to a minor, the MPC would require knowledge for each material element of the offense. Thus, if the defendant can show that she did not know that a sale took place, that the beverage was intoxicating, or that the purchaser was a minor, she will be able to avoid the liability. General state of mind requirements, recklessness. If the statute defining the offense other than a strict liability offense does not include a state of mind requirement, the defendant must have acted with at least recklessness with regard to each element of the offense. A higher degree of fault suffices. Under the MPC's hierarchy of fault levels, a showing of a higher state of mind automatically satisfies a lower mental state requirement of a statute. Thus, a showing that the defendant acted purposely or knowledgeably will satisfy the general requirement of recklessness. Okay. So back to this graph right here. What would be more appropriate to say would be that purposefully is primary, that's not the right word, has priority, knowingly comes second, recklessly is a lesser degree of fault, and negligence is the last, or at least it's separate and different. So I know it doesn't look much like a cascade, so I'm gonna draw boxes so that you see the priority depicted. B, other levels of fault must be specified. Because the standard of recklessness is assumed where the state of mind is not specified, if a lower standard of negligence will satisfy liability, or if a higher standard of knowledge or purpose is required, those standards must be indicated in the language of the statute. So, recklessly is implied if statute is silent on mental state. this is a hierarchy of fault standards. Didn't know that. Stuff wasn't that readily ascertainable from the book text. That's why we read the BARBRI outline. So, moving on to page 15, there's an example. Under a statute creating criminal liability for anyone who sells intoxicating beverages to one whom he should know to be a minor, the material elements include the act of selling and the attendant circumstances that the beverage be intoxicating and that the purchaser be a minor. Under the Model Penal Code formula, a minimum standard for recklessness is required as the state of mind for the first two elements, while the third element of the statute specifies that only a negligence level of fault is required. And recklessness again. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that circumstances exist or that a prohibited result will follow, and this disregard constitutes a gross deviation from the standard of care that a reasonable person would exercise in the situation. It comes with wanton disregard, unjustifiable risks, consciously disregard it. Okay, vicarious liability offenses 7. A vicarious liability offense is one in which a person without personal fault may nevertheless be vicariously liable for the criminal conduct of another, usually an employee. The criminal law doctrine of vicarious liability is analogous to the tort doctrine of respondeat superior. Note, unlike strict liability, which dispenses with the mens rea requirement, but retains a requirement that the defendant have personally engaged in the necessary acts or omissions, vicarious liability dispenses with the mens rea requirement, but retains a requirement that the defendant have personally engaged in the necessary acts or omissions. Vicarious liability dispenses with the personal actus reus requirement, but retains the need for mental fault on the part of the employee. Limitation on punishment A under the vicarious liability offenses. Because the imposition of criminal liability for faultless conduct is contrary to the basic premise of criminal justice, that crime requires fault on the part of the accused. At least one state court has held that imprisonment in such cases violates due process guarantees of the state constitution. The current thread of the legislature is to limit vicarious liability to regulatory crimes and limit the punishment to fees. And that state's Pennsylvania, because if I remember correctly, it was Pennsylvania where a bar owner was being sent to jail because he wasn't there that day, but one of his staff members served a minor. And that was against the statute that came with a fine and imprisonment. And just as I said here, it is contrary. The imposition of criminal liability to the extent of imprisonment for faultless conduct is contrary to the basic premise of criminal justice that requires fault on the part of the accused. At least Pennsylvania held that imprisonment in such cases violates due process guarantees of the state constitution. Now remember, it is a strict liability statute that was being that he was being cited for violating, and that is serving minors. Okay, so B, under vicarious liability offenses, implying vicarious liability from underlying strict liability offense. Despite some decisions to the contrary, the mere fact that the underlying offense is clearly a strict liability offense should not imply a legislative intent to impose vicarious liability. Example, a statute makes it a crime for anyone to serve an alcoholic beverage to a minor. Although a bartender may be strictly liable for this statute, regardless of her belief that the customer was legally old enough to drink, the statute should not be construed to impose liability on the tavern owner, who neither was present at the time the minor was served nor authorized the actions of the bartender. Before I provided that story, I thought that this example did not provide it, but I was wrong. Enterprise liability or liability of corporations and associations. This is number 8. Number 8 of what? Number 8 of... I'm just trying to make sure we know where we are in the outline. Number 8 of mental state. Enterprise liability, liability of corporations and associations. Common law says there's no criminal liability. At common law, a corporation could not commit a crime because it was unable to form the necessary criminal intent. B, under 8, enterprise liability, liability of corporations and associations. Modern statutes, vicarious criminal liability applies. So, for the modern statutes, often are providing for the liability of corporations and sometimes even unincorporated associations, which in parentheses we're talking about partnerships. This liability is, by necessity, vicarious. Under such provisions, corporations may be held liable under the following conditions. This is okay. Those conditions are 1 or 2. 1, act within scope of office, and 2, superior agent rule. 1, except acting within scope of office. Except where the law specifically provides otherwise, the conduct giving rise to the corporate liability must be formed by an agent of the corporation acting on behalf of the corporation and within the scope of his office or employment. And 2, superior agent rule. Some jurisdictions limit corporate criminal liability to situations in which the conduct is performed or participated in by agents sufficiently high in the corporate hierarchy to presume that their acts reflect corporate policy. And that part about reflecting corporate policy is important. As we've seen in cases demonstrated. Model Penal Code C, under enterprise liability, liability of corporations and associations. We've talked about it in common law, modern statutes, and now under the Model Penal Code. A corporation may be guilty of a criminal offense provided the offense 1, 2, or 3. 1, it consists of the failure to discharge a specific duty imposed by law on the corporation. 2, is defined by a statute in which legislative purpose to impose liability on corporations plainly appears. Or 3, was authorized, requested, commanded, performed, or recklessly tolerated by the board of directors or a high managerial agent acting on behalf of the corporation within the scope of his office or employment. And D, under number 8, enterprise liability, liability of corporations and associations. D, individual liability independent of enterprise liability. The person who, in the name of the corporation, performs or causes to be performed the conduct that is an element of the offense is legally accountable and subject to punishment to the same extent as if the conduct were performed in his name or on his behalf. Similarly, the fact that the corporation is liable does not prevent the conviction of the individual who committed the offense. Transferred intent 9. If a defendant intended a harmful result to a particular person or object, and in trying to carry out that intent caused a similar harmful result to another person or object, her intent will be transferred from the intended person or object to the one actually harmed. Any defenses or mitigating circumstances that the defendant could have asserted against the intended victim, for example, self-defense or provocation, will also be transferred in those cases. The doctrine of transferred intent most commonly applies to homicide, battery, and arson. It does not apply to an attempt, meaning that there has to be harm. Example, A shoots at B, intending to kill him. Because of bad aim, she hits C, killing him. Is A guilty of C's murder? Held, yes. Her intent to kill B will be transferred to C. Note that A may also be guilty of an attempted murder of B, but not C. Compare. A shoots twice at B, thinking that B was C, whom she wanted to kill. She wounds not only B, but also D, a bystander. Is A guilty of the attempted murder of B and D? Held. A is guilty of the attempted murder of B because her mistake as to B's identity is a mistake of fact that does not negate her intent to kill the person in front of her. B. There is no transferred intent issue in that scenario. However, most courts would hold that she is not guilty of the attempted murder of D. And 10, under mental state, is motive distinguished. The motive for a crime is distinct from the intent to commit it. A motive is the reason or explanation underlying the offense. It is generally held that motive is immaterial to substantive criminal law. A good motive will not excuse a criminal act. On the other hand, a lawful act done with a bad motive will not be punished. For example, an impoverished woman steals so that her hungry children may eat. Despite her noble motive, feeding her children, the woman could be held criminally liable for the acts because her intent was to steal. Now we're going to finish section 2 here because we have left D and E. D is concurrence of mental fault with physical act required. The defendant must have had the intent necessary for the crime at the time he committed the act constituting the crime. In addition, the intent must have prompted the act. Example, A decides to kill B. While driving to the store to purchase a gun for this purpose, A negligently runs over B and kills him. Is A guilty of murder? No, because although at the time A caused B's death, he had the intent to do so. This intent did not prompt the act resulting in B's death, i.e. A's poor driving. Compare. With the intent to kill B, A strangles B to the point of unconsciousness, but does not actually kill B. Thinking B is dead, A buries B, and B dies as a result. Is A guilty of murder, even though the death-causing act of burying B was done without the intent to commit murder? Yes, in a majority of jurisdictions, most courts would find that the two acts are part of a single transaction with a common intent. And E, causation. Some crimes, example homicide, require a harmful result in causation. For a full discussion of causation, see another section, 5. Section 3 is accomplice liability. And I want to spend some time talking about this because it's complicated. Section 4 is inchoate offenses, which are solicitation, attempt, and conspiracy. Now I finally know what inchoate means. or at least I have an idea what it means. Conspiracy, solicitation, and attempt. What was Section 5? I know we were going to talk about concurrence in Section 5. Well, it's not really important because responsibility and criminal capacity. So in Section 5, we'll be talking about some defenses. Surprisingly, under that title, you wouldn't think insanity would come up. And diminished capacity, and infancy, and intoxication. But it does. In Section 6, we're talking principles of exculpation. And it starts with justification being self-defense, defense of others, defense of a dwelling, defense of other property, crime prevention, use of force to effectuate arrest, duress, necessity. Now, what was the difference between principles of exculpation and responsibility and criminal capacity? You just have to remember that responsibility and criminal capacity involves the defenses of insanity, intoxication, infancy, whereas exculpation is justification for the crime, and the defenses that are available sometimes under certain circumstances, again, for justification is self-defense, defense of others, defense of property, defense of, dwelling, other property, crime prevention, use of force to effectuate an arrest, necessity, public policy, and domestic authority. There's also duress, which is called compulsion or coercion, and necessity does fall within that. Other defenses are mistake, ignorance of law, which sometimes works. And now, then, at some point when we're on page 47, we're going to get into what we really need to know, which is the definitions of the crimes. Assault and battery, offenses against the person. Sexual offenses I know to be, mayhem, homicide. Jumping the gun. But then we'll get offenses against the property. And will that be the last section? Is it possible that offenses of property could be the last section? Yeah, because I know that arson is on like the second to last page, so that's where we'll end it. No, offenses involving judicial procedure is going to be last, which involves perjury and bribery, compounding a crime, and misprision of a felony. Okay, that's where we'll leave off today. Thank you.